Oh, 153 participants. I'll give it a couple more minutes to 7:05. Kwe Bojo. Welcome to another fantastic Amnesty International Canada webinar, folks. Tonight we are looking at legislating the UN Declaration on the Rights of Indigenous Peoples and understanding some of the history of advocacy at the international arena for the respect for inherent rights. Nodin Kwe Indigenous Cause, Odawa, Minwa Oga, Minwa Aki Bakanaze Ndonjaba. My name is Anna Collins, and I am the Indigenous Rights Advisor at Amnesty International. I'm really happy to be with you here today and with our guests. If you want, can you give us a little hello in the chat and let us know where you're located? You can let us know whose territory you're living in, and you can let us know where your ancestors are from. Anishinaabe Aki Nindabitan, and in different non-pandemic times, I work in Amnesty's Ottawa office. We are joined tonight by 3 knowledge keepers, language speakers, community leaders, and just generally superstar, awesome people who have taught me a lot. I wanted to gather into conversation tonight around legislation to adopt the UN Declaration on the Rights of Indigenous Peoples, because there are a lot of questions about its meaning and what it might bring to settler and Indigenous relations. To start, there is a long history of Indigenous advocacy at the international level, facing colonial nations, trying to talk to the League of Nations, and eventually the United Nations. And it is due to the leadership and foresight of past leaders that Indigenous peoples have come to be seen globally as distinct peoples with human rights and other rights, and with important cultural traditions, sciences, languages, spiritual practices, legal systems, and societies. For more than 30 years, Indigenous representatives have traveled from every corner of the globe to the UN, bringing their ancestral knowledges, experiences, and expertise in order to explain how human rights apply specifically to Indigenous peoples and to make sure that nation states also understand. Just like the world has the UN Convention on the Rights of the Child, or the Convention on the Elimination of All Forms of Discrimination Against Women, the world needed the wisdom and leadership of Indigenous experts in order to correctly understand how human rights apply both collectively and individually to Indigenous peoples, and to put that guidance into an international human rights instrument. The United Nations Declaration on the Rights of Indigenous Peoples was adopted by the General Assembly on Thursday, the 13th of September, 2007, by a majority of 144 states. There were 4 votes against. I'm sure many of the folks on this call know that Canada was shamefully one of the 4 countries that originally voted against. But finally, Canada endorsed the declaration in 2010, and subsequent governments have struggled to create legislation, beginning with a few private members' bills, including Romeo Saganash's bill C-262, and more recently, the government bill tabled last December. The declaration affirms the rights of Indigenous peoples to self-determination and to their languages and cultures and traditional territories. The rights explained constitute the minimum standards for the survival, dignity, and well-being of the Indigenous peoples of the world. I hope that all of you, the participants on the call, received the resource document list that I think we received this morning, actually. And I hope some of you even had time to look. I thought maybe everyone's sick of sitting on the couch and what clicks yet again. So you might appreciate some new subject matter. Whilst the panelists are speaking, please feel free to write questions in the chats as they come to you. And if you're watching on Facebook, you can question in the comments, and we'll get back to them later if there's time. So enough from me. We have these experts here. They have a lot to teach us. I'll start by giving a short bio and then invite each speaker to speak for a few minutes about the importance of legislation. Our first speaker is Brenda Gunn. She's a Métis Associate Professor at Robson Hall Faculty of Law. She also worked at a community legal clinic in Rabinal, Guatemala, on a case of genocide submitted to the Inter-American Commission of Human Rights. She continues to be actively involved in the International Indigenous Peoples movement, regularly attending international meetings. Brenda provided technical assistance to the UN Expert Mechanism on the Rights of Indigenous Peoples and analysis and drafting of a report summarizing a survey on implementing the UN Declaration. She developed a handbook on understanding and implementing the UN Declaration and has delivered workshops across Canada and internationally. Miigwech for joining us, Brenda. From your perspective, why is legislation so important?
Thanks, Anna. And thanks to Amnesty International for organizing this panel and for inviting me and allowing me to sit with these very esteemed gentlemen. I am honored and a little intimidated to be here today. I am grateful I get to speak first because I'm not sure I'd want to speak after them. And I'm hoping they can correct anything that I misspeak about. But if I think about why legislation is important, I really think about the idea of international law and international human rights law in particular. And one of the challenges that we constantly face is the idea that law isn't always viewed as law in Canada, or isn't viewed as real law, or it's not enforceable law. And it's always sort of, there's groups of people who are always trying to push it aside. And so in international law, there is this idea that states are obligated to domesticate standards, right? And I know this word domesticate has a really negative connotation in Canada, particularly in relation to historic treaties. But I think it's important to understand that the idea is that under international law, states like Canada are required to take international law that exists out there in the world, in the UN area, and actually bring it home and implement it in Canada. And so when we speak of domesticating international law, we don't mean sort of taking away that international character, but it's actually the process to implement law in Canada. So from my perspective, I think it's really important to think about passing legislation that is speaking to the implementation of the UN Declaration to really clarify and hit home that the standards and the rights set out in the UN Declaration are real law. They're really standards that Canada must uphold. And it really addresses that hesitancy that Canadian courts have when looking to international law. If we look at, Canadian court decisions since 2007, it has been really uneven. The courts have shown in some cases a lot of ignorance on how international law applies. And so by taking the UN Declaration and passing legislation that says it clearly applies and Canada should uphold these standards, it really takes away that element of uncertainty of, what is the UN Declaration? Is it really law? Does it really apply? It takes all of that out, loses that distraction and has us focus on the work of actually implementing it. And then I think the only other point I would raise at this time is that the legislation as conceived initially by the Honorable Romeo Saganash and repeated in Bill C-15 is the idea of a national action plan. And I think it's really important to understand that the idea of a national action plan is something that is grounded in the advocacy of Indigenous peoples internationally. So when the World Conference on Indigenous Peoples was held at the United Nations, Indigenous peoples negotiated with states to come up with a plan to implement the UN Declaration. And one of the biggest aspects that Indigenous peoples were pushing for was for states to develop a national action plan. And so Canada, while it wasn't fully supportive of the idea and of the outcome document at the World Conference, has now shown some commitment to undertaking this national action plan, something again that Indigenous peoples advocated for quite strongly. And so I think for me, it really is a requirement of international law that states have to take these international standards and bring them into Canadian law. It addresses the hesitancy and the ignorance of Canadian courts on how international law applies in Canada. And it fulfills one of the major requirements that Indigenous peoples were pushing for, which is Canada develop a national action plan to implement the UN Declaration. Thanks.
Miigwech, Brenda. Very clear. You've convinced me. So our second speaker is Grand Chief Wilton Littlechild. He is a Nahalo residential school student and thriver who was appointed as commissioner to the Truth and Reconciliation Commission of Canada, where he served for 6 years until the final report. Grand Chief Littlechild is a lawyer who has worked both nationally and internationally, including with the United Nations, to advance Indigenous rights and treaties. Grand Chief was a member of the 1977 Indigenous delegation to the UN, and he worked on the declaration. He organized within the UN to increase Indigenous output in the economic and social issues the UN tackles. Grand Chief Littlechild was a member of Parliament, Vice President of the Indigenous Parliament of the Americas, North American representative to the UN Permanent Forum on Indigenous Issues, and a chairperson for the UN Expert Mechanism on the Rights of Indigenous Peoples. Willie is an avid sportsman and an athlete. He has won more than 70 provincial, regional, national, and international championships. He was a founder of the North American Indigenous Games and was selected as torchbearer and ambassador for the 2010 Olympics. And he has been inducted into 7 sports halls of fame. Miigwech for contributing to our conversation today, Grand Chief. What reasons do you see for adopting federal legislation?
Well, thank you very much for that introduction, kind words. Migan, Xemanto na naskamawa semina pegom stagi weoche, ehinamagoyak, the big square, the big squat mak. Kansan magetsna utehnikan, the miopike, ki goi, the miwicheto, the miwakoto. Tami o tuskewe, tusketo, ekse, nanaskum stay. Ogumino kawit the make, nanaskumak. Maikan mote on sigasa. Mascotsi sigotse. I just greet you in my language to introduce myself with my Cree name, Walking Wolf, from the Musqueam in Treaty 6 territory. And said in my remarks that I was grateful to Great Spirit or God, whichever way we acknowledge our Creator, of gratitude, sincere gratitude for this opportunity to join colleagues on the panel, whom I also, in return, respect highly for the work they have done, the accomplishments they have made throughout their careers. For a short introduction, Anna, it's a doctor, lawyer, Indian chief, and then that's it. So, but in any event, that was my long bio, and apologize to the audience for that lengthy introduction, but I think legislation is important because that's how Parliament works. That's how Parliament speaks. That's how Parliament expresses its decisions. And if I can give a quick example in a parallel way, I think there was a Migratory Birds Convention years ago to allow Indigenous peoples to hunt, fish, and trap. And this one was specifically for migratory birds. There was a treaty between Canada, United States, and Mexico. So it was an international convention. It was an international treaty. But in order to make it apply in Canada, Canada had to pass legislation, much similar to what Dr. Gunn has just provided us with background information. So the result was that Canada adopted legislation called the Migratory Birds Convention Act in order for that international treaty to apply in Canada. So similarly, the United Nations Declaration, although it's a declaration on the rights of Indigenous peoples, in order to apply in Canada, we need legislation to do so. So I think that's the importance of it. That's how Parliament works, and that's how Parliament speaks. So thank you.
Our third speaker is going to get an equally long introduction. But I hear what you're saying, Grand Chief. Romeo Saganash was the Yush Member of Parliament from 2011 to 2019. He grew up in the forests of northern Quebec and was a survivor and a thriver of residential school. After he finished school, Romeo was asked by his chief to attend a conference on the 10th anniversary of the signing of the first modern treaty in Canada, the James Bay and Northern Quebec Agreement. It was there that he learned about law and became curious about law. He's the first Indigenous lawyer from the Université du Québec à Montréal. He was one of the authors of La Paix des Braves, which was a landmark agreement between the James Bay Cree and the government of Quebec. He has been a key negotiator for many national and international initiatives, including the United Nations Declaration. He founded the Cree Nation Youth Council, served as Deputy Grand Chief of the Grand Council of the Cree for a number of years, and he is a passionate environmentalist. Miigwech for sharing with us today, Romeo. Why do you think that UN declaration legislation is necessary?
Ka wishamgian jimi dugochuda shibes bitsmangia datemon suggestion wabmak stash Willie and suggestion wabdan nwakmagan Brenda and you made mean wabdan anakia and nastabin suggestion wabdangia chui madnon istamgia nastawa Emietmanga Kawishamgan is Yamud Manua, Wishwam Shanigan, C15 is Ngadech. Nastawam Salga, Nutuoka Betamok, Nistam Gabet Snegno to Machinigan, Eganmagpsis, Kawi Yamud Mani. Well, first of all, thank you very much for the invitation. I'm honored to be on this panel with two people that I admire very much, Brenda and Grand Chief Willie Littlechild. I think one of the first things I would like to mention that the three core elements of Bill C-15 are important to remember. That first of all, that the UN Declaration on the Rights of Indigenous Peoples has application in Canadian law. and I want to briefly talk about that aspect. Second of all, that the implementation of this declaration will be done through the development of an action plan, implementation plan in consultation and cooperation with Indigenous peoples. The bill talks about 3 years maximum, or as soon as practical. I think that's an important element in the sense that if we're going to have, we have over 600 First Nations communities in this country, as well as Inuit and Métis in this country. So in order to achieve something that important, implementing the UN Declaration on the Rights of Indigenous Peoples and the minimum standards it contains, that may be reasonable because different communities, different nations will have different priorities, and which fundamental right they wish to start with is going to be an important consideration for all of these communities. So it's important to be mindful of that aspect in terms of implementation. And thirdly, the third core element of the bill is the government of Canada is asked to make sure to do everything necessary that the laws of Canada are consistent with the UN Declaration on the Rights of Indigenous Peoples. For 8.5 years as a member of Parliament, one of the things I lamented about for all this time as a member of Parliament is the fact that we have something in our legal system, in the legal system of Canada, and in Parliament, in the parliamentary process. And it is this: the Department of Justice Act under Article 4.1 requires that the Minister of Justice make sure that any legislation before it is introduced is consistent with the Charter of Rights and Freedoms. And we don't have the equivalent for Indigenous rights or treaty rights in this country. And we should, because one of the main reasons why we always end up in court is the fact that Parliament, both the Parliament of Canada and the legislatures in the provinces seem to be adopting legislation all the time that are contrary to our treaty rights or Aboriginal rights, although we've had so much jurisprudence and case law that support Aboriginal rights. So that is something that we need to fix. And Bill C-15 will contribute, in my view, to fixing that. When we say that Government of Canada must make sure that all laws are aligned with the UN Declaration, well, that's going to have the effect of making sure that they adopt laws that respect the minimum standards of the UN Declaration on the Rights of Indigenous Peoples. So that's the first point I wanted to add to what has been said so far by Brenda and Willie. The fact that what Bill C-262 wanted to do and what C-15 continues to try to do is to make sure that it is recognized, so it doesn't become a matter of debate before the courts, is that international instruments like declarations, including the UN Declaration on the Rights of Indigenous Peoples, have application in Canadian law. What that means is that our courts and judges in these courts are impartial, and they can refer to or reference international instruments like declarations, like international treaties, like international conventions, and so on, to interpret rights in this country. And they've been doing that. I always remind people of the 1987 reference case. It was an Alberta reference case where the former Chief Justice Dixon mentioned that these international instruments, and he enumerated them, starting with declarations, conventions, and treaties, and so on. He said in that case, in 1987, that these instruments are relevant and persuasive sources to interpret domestic law. And courts have been doing this even before the UN Declaration on the Rights of Indigenous People was even adopted by the General Assembly in 2007. Human rights tribunals in this country have referenced the UN Declaration even before 2007. So it has that use for tribunals and courts. The latest case I saw was the Nunatukeewit Community Council versus Canada. I believe this was in 2015, a case from Labrador, where the federal court said that UNDRIP may be used to inform the interpretation of domestic law. So more and more, I think, courts will be referencing the UN Declaration on the Rights of Indigenous Peoples to interpret fundamental rights of Indigenous peoples in this country. It's happening elsewhere. For instance, in Bolivia, in Colombia, Belize, and none of these countries have the equivalent of C-15 adopted by their parliaments, but yet the courts in these countries reference regularly the UN Declaration to interpret Aboriginal rights or Indigenous rights. I'll stop there. I'm anxious or eager to go to the questions. Thank you.
Miigwech, Romeo. Sorry to cut you off there. So I'd like to move to the second part of our webinar, where I have some questions, and I invite our panelists to answer and respond to each other. These are really hard questions. I want you to, brace yourselves, get ready for it. First one I would like to ask all of you is, do you have a favorite article of the Declaration, and which one and why? Does anyone want to go first with that one? This one's really hard, I know. It's hard to choose one, but they're so varied.
Yes. Since I went last, I'll go first on that one.
Okay.
It's really difficult. I think Article 1 is the important one for me, as it confirms that all international instruments in regard to human rights also apply to Indigenous peoples. I think we tend to forget Article 1 when we talk about the UN Declaration on the Rights of Indigenous Peoples. But I also have a favorite preambular paragraph, and that's the second one. The second one reads, affirming that Indigenous peoples are equal to all other peoples while recognizing the right of all peoples to be different, to consider themselves different, and to be respected as such. I think in terms of the difficult relations that we have in this country, if we started with simple things like that preambular paragraph, we'd go a long way.
Brenda or Willie, do you have a favorite article or preambular paragraph? I stand corrected on that.
Well, I had Article 1 and 2 down when I was thinking about this. And then when I asked my spouse, I was like, I don't know, what would be my favorite? And he's like, oh, the preamble. So now I feel like I need to come up with a more original answer because Romeo stole my answer. So I guess am I on to my second or third favorite? I would say after Article 1, my second favorite is Article 2. Because it's about non-discrimination, right? So we have equality and then non-discrimination. And I think that speaks also to the preambular paragraph that Romeo was speaking about. So this idea that Indigenous peoples are peoples, but also this idea that we shouldn't be discriminated against for being Indigenous, right? So I think I tend to think of those two together. And beyond that, I'm not sure I can think of another one on the fly.
Grand Chief. Oh, you're muted, Grand Chief.
I'm going to give you 3 favorites. Since 1 and 2 have been taken, I'll go now to 3. Article 3, of course, is on the right to self-determination, which is really the fundamental pillar of the Declaration itself for every single article that follows, and paragraphs that precede it, including the preambular paragraphs. As far as a favorite, Article 37 on treaties. And I say that because when I think back to 1974, 75, when I initially was called on to consider going to an international conference on treaties, it was not till 1975 when our elders agreed to actually write down their understanding of what treaties were or are in the Indigenous language. So the elders in my community, after many ceremonies and deliberations and prayers, called me in to talk about going to the international arena because they were so concerned about daily violations of our treaty, in this instance, Treaty Number 6. And they said you should go international to remind our treaty partner, Her Majesty the Queen, that we have a treaty, a peace and friendship treaty with her, and it's being violated every single day. So that was the start of my journey back to 77 with 2 interruptions. One was there happened to be an ILO convention conference going on as far as Indigenous peoples were concerned in Sweden, Kiruna, Sweden. And I was asked if I would be willing to chair the meeting on ILO Convention 107, which was the only existing, at the time, legally binding international law for Indigenous peoples. But it was very assimilationist or discriminatory in terms of some of the wordings. And they asked me to chair that session, and I did. And after I was done, they said, well, now that you've chaired this meeting, you know our positions. Now you go to Geneva and meet with the ILO and get it changed. So off to Geneva I went, and to find out that it was a 2-year process to amend an international labor organization convention, which sounded good to me. 2 years, it's not bad. But then as we worked to amend the ILO convention, I quickly found out that they could only deal with economic, social, and cultural rights as a labor instrument. So they would not allow any discussion for civil and political rights, like the right to self-determination. They said, you have to go to the UN for that. So after the UN, I went because coincidentally, there happened to be a conference on land dispossession and discrimination against Indigenous peoples. So there were almost 150 delegates from all over the world. None of us could get into the UN. So with elders doing ceremony, we had a peaceful walk into the UN, only to find out that we couldn't speak because you had to have NGO status to take the floor or be a state delegate. So we had to borrow NGO time for 3 minutes, for example, to take the floor and address the assembly. So 3 became a very important article for me because the instructions I received were Neogi goy hegawi kats asega pistamo kano he neonika neogi goy stamo ma kikpakin goson uyotamason te bemoin ektoche aski kana hoche kichoi tsigona. So they gave me 4 instructions in Cree, and they said, do not ever back off on any meeting on these 4 principles. That one first principle was that we have inherent rights. Secondly, we have a right to self-determination. Thirdly, we have oral testimony by which we understand our version of treaty. And fourthly, consent. Those are the 4 major items you should always abide by. Let those be your guide. So for all the years I was there, those were my guiding principles. And I come back to 3 for a second reason, if I may just take a few more seconds. It's kind of funny in a way, but it's really in a roundabout way, very serious. When you introduced me as an athlete, when you combine Article 3 with Article 31, that gives you the foundation, gave me the foundation to actually establish the North American Indigenous Games and the World Indigenous Games. Because in no other way, in no other events, can you actually visibly display that you do have a right to self-determination. You do have a self-government. And when you enter the games in the opening ceremonies, for example, we have a flag, our traditional flags that we carry, just much like the Olympic model. So 31 includes cultural heritage and cultural manifestation. It's probably one of the 4 pillars of the UN Declaration, culture. But in that, you'll see there's a wording that refers to sports and traditional games. So and yes, I'm very biased on that in that sense, but 3 and 31 are very favorites of mine because that's how you actually visibly display the fundamental right to self-determination as Indigenous peoples, and also implement the UN Declaration at the same time. So I apologize again for a long roundabout answer, but 37 has to be my favorite. That was the purpose I was sent there. But then I found my way into the UN, which led me into the human rights area.
I think that's really a practical example of these aren't lofty rights. These are just general experiences that humans have, sports being one of them, right? And it's so tangible for me to hear you say that. Okay, I'm going to move on to a harder question now, if you're ready for that, since we did the easy one. So BC passed the UN Declaration legislation a few years ago, And C15 was tabled in December and rests at first reading at the House. There's been a little bit of debate a couple of weeks ago, but it's preparing to go to committee. So in terms of C15 as legislation, I guess a question I hear a lot is that people aren't sure exactly what it is in C15 that will see rights implemented in really concrete terms. What is the accountability process, and what is in that bill that ensures that rights will be respected? Does anybody want to start?
That is a hard one, but let me answer it backwards with your last point, and that is when you look at the missing pieces you just referenced, for example, a monitoring oversight mechanism, the answer is within the declaration itself. And by that, I mean, you take a cluster of articles, for example, 27, 28, and 40. When you take those three articles together as a cluster, you create a conflict resolution mechanism with that cluster. And that takes you to a point where you don't have to go to court. You can resolve your conflicts internally and also implement the declaration at the same time. So you take a cluster of three articles, I think, in a way that would be unique. Again, it implements the UN Declaration as well in that way, because you're using it, three articles at the same time in a cluster to resolve conflict or dispute, and while you're implementing declaration at the same time. So what's in the C15? Well, the reference to that as an example, that the ability to use the cluster for implementation.
Right. Romeo, I know your C262 had a reporting mechanism in it. Maybe you want to speak to that and how that's reflected in C15.
Well, I've said publicly before that C15 is pretty close to 262. The only, well, at least in my view, the only big difference that I see is that the non-derogation clause in C15 has different wording than what I had in C262. I think that needs to be noted. This is a federal legislation matter, as a matter of fact, that has been ongoing. We have non-derogation clauses in federal legislation that are different, various ways of drafting such clause, and I think once and for all we should close this file by adding a provision in the Federal Interpretation Act that would serve for all federal legislation, so that we don't have these different varieties of or ways of drafting a non-derogation clause. C262 used or was inspired by Article 45 of the UN Declaration, whereby in C262, I essentially said that this act shall not be construed as diminishing or extinguishing the rights of indigenous peoples. C15 uses derogation, abrogation. Derogation and abrogation. So every time I hear the word abrogation, however it is drafted in the legislation, it triggers me, as it does, I'm pretty sure, for all. One of the concrete ways that, just to give an example, how you can use the declaration concretely. Back in early 2000, we negotiated an agreement with the government of Quebec called La Paix des Braves. And one of the areas that we wanted to protect was Mushkogee, which means the Bear Hill. Mushkogee was a place where the Cree people wanted food when there was food shortage. That's where the Cree people went to get their food. So it's a sacred hill for the Cree people. And we used Article 25, and this is early 2000, even before the declaration was adopted by the UN General Assembly. We used Article 25 that recognizes the spiritual relationship that Indigenous peoples have with their lands and resources, and integrated that right in La Paix des Braves in 2002. In fact, if one reads this agreement with Quebec, especially in regard to forestry development in the Cree territory, we even incorporated in that agreement the Cree law concept of consent. Our understanding in Cree law of consent is very different from others' understanding of consent. So if one reads the process that is in that agreement, in that particular agreement of 2002, it describes how you achieve or gain consent from not only the Cree Nation, but the rights holders on the ground, the ones that have a constitutional right to continue with their way of life of hunting, fishing, trapping, and gathering. So there's a Cree law concept of consent in this particular agreement. So this is just one example how you can use the declaration even in negotiations with governments.
For the non-lawyers among us, myself included, Brenda, maybe before I see you're going to make a comment, but what is non-derogation? What is abrogation? What are these legal terms that are in these laws? What does that mean? Or Romeo, if you want to respond to that. Maybe none of us actually know what it means. It's just a word we keep using. Are we working? Are we having mic problems? Okay, Brenda.
Well, I don't know if I have a good answer for this, and you may hear a toddler very sad in the background. So I might have to step away for a moment. You know, I feel like I'm stepping into something and I'm not sure I want to, and I'm trying to find my just constitutional law prof hat. But I think I'm going to take Willie's approach, and I'm going to go around your question and maybe come back and maybe one of my co-panelists can come up with a idea. But I think when we think about these these challenges, you know, I think a lot of the wisdom in the bill is the attempt to create accountability and to think about realistically, what does legislation do? What can the government do? What are the tools we have to really hold the government to account, to uphold Indigenous people's rights, to uphold our rights as we understand them? And so, so sorry, I might just need to, but so I think the point is, through a national action plan, it creates space where Indigenous peoples have a set time and process and space to have the conversations, to continue to articulate the rights as we understand them, right? Like, I think Romeo's words there about how do Cree people understand consent, that's really important, right? And so there's not a lot of spaces right now in the current parliamentary system, in the current governance system, where those conversations can be had, right? And so while not answering what does derogation and abrogation mean, I think the wisdom of the bill is that it's setting up space to have those conversations, to make sure that we're still actively involved in defining and explaining the rights and coming up with a plan to implement them. And so I think that is just something that we don't want to lose sight of. And I also think we want to make sure that we're not setting unrealistic expectations about what any legislation can do, but I really see it as being another tool, right? And something else we can try to push for greater recognition of our rights. And sorry.
Well, if I may add to all of that, generally non-derogation clauses are instituted to uphold the rights that you have now or may acquire in the future. So it's a safeguard, in fact, of what you have as rights, inherent rights right now. If I can read you Article 45, and it's pretty clear, nothing in this declaration may be construed as diminishing or extinguishing the rights of Indigenous peoples have now or may acquire in the future. In fact, Article 2.2, which is the non-derogation clause in C15, if you read the French version of 2.2 or 2.2 of C15, the French version of the non-derogation clause was much more clear than what the English version says. So I think it's just a safeguard, in my view. It doesn't add or diminish or extinguish any rights that Indigenous peoples have presently. And that's what generally non-derogation clauses are instituted to be. It doesn't affect anything in any way.
Grand Chief, do you have anything to add to this idea of practical holding the government to account and making sure that this bill doesn't just isn't just words?
Well, I think that the visual of a shield is important in terms of non-obligation or non-derogation. To me, put simply, you can't walk away from your responsibility or obligation. For example, with a treaty agreement, you cannot derogate or abrogate. So you can't walk away from a legal obligation that you have agreed to or violated, for that matter. But I think I'm trying to recall the Senate study that was done on non-derogation clauses and how they came down on a preferred wording that would apply. I think my brother Romeo alluded to it earlier in his comments about the importance of just having one statement, if I can say it that way, that covers all aspects. And I think that was the Senate conclusion as well, if I remember right. But you just can't simply walk away from your responsibilities.
It's pretty powerful. So I'm looking at some of the questions that we've been getting from folks here. And there's some really practical questions around things like, what will, well, the favorite one that we all like to talk about, what might C-15 do for the Indian Act? The Indian Act, for those who haven't had the pleasure of reading it, really outlines Canada's obligations to Indigenous peoples, treaty Indians, status Indians, and talks about a lot of stuff like governance and access to healthcare and reserve lands and who can and cannot live on reserve. It's pretty colonial and rigid piece of legislation. What could C-15 or UN Declaration legislation in general possibly do for the Indian Act and other pieces of legislation that have been developed over the decades without Indigenous peoples' involvement, without free, prior, and informed consent? I see, Romeo, you have a look on your face. Does that mean you have an idea?
Well, I can take a stab at this one. I think once this legislation is in place, if First Nations communities or just one First Nation decides to challenge the Indian Act as being incompatible or inconsistent with the UN Declaration on the Rights of Indigenous Peoples, that First Nation or those First Nations would win the case. Because clearly the Indian Act is inconsistent or, to speak the UN language, incompatible with the right of self-determination of Indigenous peoples in this country. Pretty clear to me. As early as 1999, and Grand Chief Littlechild may remember this, as early as 1999, the Human Rights Committee that is responsible to oversee the implementation of the International Covenant on Civil and Political Rights, among other instruments, determined that the right of self-determination under Article 1 of the International Covenant on Civil and Political Rights applies to Indigenous peoples. The Grand Council of the Cree were one of the interveners in this hearing of the Human Rights Committee, not the Commission or what is now the Council, but the committee that oversees the implementation of this international, very important international human rights covenant. So we intervened and we argued that that right of self-determination under Article 1 of that covenant applies to Indigenous peoples, certainly applies to the Cree. And the committee established and concluded in their final observations that yes, Article 1 of that international covenant applies to Indigenous peoples. So when we were at a point during our discussions and negotiations and drafting of the UN Declaration, when most of us felt that we had advanced on our discussions with respect to the right of self-determination, let's not forget that nation states during those negotiations wanted to qualify the right of self-determination of Indigenous peoples, which we refused because you cannot discriminate under international law, certainly not under the UN Charter. So at that point, I almost left the UN and go back home because I knew that the right of self-determination nevertheless applies and to Indigenous peoples. And the same can be said about C-15 and C-262. With or without C-262 or C-15, the courts will continue to use the UN Declaration on the Rights of Indigenous Peoples to interpret domestic law. It's the international instrument that informs constitutional and other rights in this country, and not the opposite. It is not the Constitution that will inform the right of self-determination of Indigenous peoples. Just one last point on that. I know that under Article 9124, Section 9124 of the Constitution Act of 1867, it is true that the jurisdiction over Indians and lands reserved for Indians is a federal responsibility. I have not seen to this date any jurisprudence or case law that interpreted what lands reserved for Indians meant. Is it just the reserved land? Or is it, for instance, in the case of the James Bay Cree in northern Quebec, the entire territory covered by the James Bay and Northern Quebec Agreement, because we have constitutional rights under that James Bay Treaty over the entire traditional territory of the Cree. So can we apply that as lands reserved for Indians as well? So these are the kind of questions that are raised throughout, but definitely I think the Indian Act would be considered incompatible with the right of self-determination of Indigenous peoples.
I don't know if I have much to add to that, but I think just to echo from my perspective, the UN Declaration and any legislation that's seeking to clarify the relevance and application of the UN Declaration in Canada supports inherent rights, including inherent rights like the self-determination, like Romeo just so eloquently spoke about. And also, I think, as Willie has already pointed out, it supports treaties and treaty-based governance and treaty relationships. And so, I mean, no one knows the magic wand that'll sort of make it poof disappear. But I think when I think of the aspirations and the directions and, you know, sitting with elders and sort of the goals that have been explained to me, I see that the UN Declaration really supports that work. And we see it in some clear ways beyond just provisions that confirm the right to self-determination and that confirm treaties, but the provisions that speak to Indigenous people's own institutions, Indigenous people's own governance, the right to sort of determine citizenship. Like, there's lots in there that really speak to the sort of, there's references to Indigenous people's own laws, customs, and traditions, right? So it's all there, and it just seems like a really powerful tool for those nations that are looking to, I don't know if I say move beyond the Indian Act or no longer want to be in that relationship. It seems to support all of those aspirations and those efforts and confirms those rights, right? It's not giving any rights, but really confirms the inherent right to govern oneself in relation to their own customs, laws, and traditions.
Thanks, Brenda. And that's really important too for Métis peoples, right? Where there's been a series of court decisions to try to define what government obligations are to Métis, because there isn't so cut and dry with no Métis Act, right? And so, really going back to Article 3 and emphasizing self-determination and the right to determine membership and the right to determine right to governance and legal systems without having to ask permission from the nation state. I'm gonna look at the questions here. We've got so many coming in. We're gonna run out of time, folks. I'm so sorry we won't be able to get to all of these. To go back to the practical, I guess, aspect in a way, we're looking at issues of drinking water, discrimination against First Nations children, the child welfare system, these very practical right to well-being considerations that the federal government seems to continue to not address, right, to not remedy. So in a practical way, when folks are gathering in collaboration and looking at the development of this national action plan, what kind of things would you like to see on that national action plan? What's your number one? What for your communities, your nations, what kind of things would you like to see worked through in terms of implementing Indigenous rights practically for your nation? I told you they were going to be hard.
Well, maybe I'll give you an example. And I'm doing it, not having asked the leaders or elders if I can use this as an example, but practical, you say. Well, we, as acting as an Indigenous government, adopted and endorsed the UN Declaration in early 1982, I believe. So we've been using the UN Declaration in our territory ever since then. So we've been applying it, including the two specific references to water. When you talk about water, there's two articles specific to water. So we use those. Just recently, we amalgamated all of our schools, all of our 11 schools in our territory, amalgamated them under one and used Article 14 of the UN Declaration to do that. Because we had adopted it before Canada did. We didn't wait for Canada to make a law, and we just went ahead and started using it ourselves. And we've been doing it since. It's for example, our tax law, our land law, our Education Act, all are based on articles of the UN Declaration and the right to self-determination. So we've been using it. We didn't wait. Maybe that's kind of an outlier, but there's a professor, a law professor that analyzed the 10 worst cases ever decided against Indigenous peoples. And he reread those 10 cases with the lens of the UN Declaration on top of that. So while the 10 were the worst at the time, the UN Declaration did not exist, the Indians lost every case. When he put the declaration on top of each decision, Supreme Court decision, the decision in his view would have gone the other way. So that in a way kind of motivated us to begin using it ourselves then.
Go ahead, Romeo, sorry.
Yeah, as I said at the outset, I think it's really up to the First Nations and the different Aboriginal or Indigenous nations and peoples to decide on their priorities. And I'll give you another example, concrete example. When we negotiated the James Bay and Northern Quebec Agreement in 1975, Chapter 9 of the James Bay Agreement talks about self-government. So one of the first things that we asked for after we signed the agreement is that the Indian Act no longer apply to Cree people. And the Cree-Naskapi Act, which did away with the Indian Act for the Cree and the Naskapi, and replaced it with the Cree-Naskapi Act, was one of the first negotiated pieces of legislation between First Nations and the federal government. This was a negotiated and agreed upon legislation for self-government in the case of the Cree. So it's really, if I had the choice today to determine a priority, I would go for the Articles 25 and following that pertain to lands, territories, and resources, because that's what will allow Indigenous peoples not only to survive, but to thrive in this country on their own resources, on their own lands and territories. I remember when I got elected in 2011, one of the journalists asked me, don't you find it difficult that Indigenous people in this country cost a lot of money to the federal government? I said, no, I think it's the opposite. I think the governments in this country take a lot more than what we get back from our from the development of our own resources and territories. We should change that discussion as well. And as we move along, we need to recognize, and I want to make this point as clear as possible. We need legislation to confirm that international instruments like declarations apply in Canadian law. We need that. We need also to recognize that this is just another legal framework at the disposal of Indigenous peoples. We have the Constitution, Section 35 rights. We have our treaties. We have our laws, Indigenous laws, and we have international law. These are all distinct and different legal frameworks that we can use, that we continue to use, and none supersedes the others. They are all interrelated and mutually reinforcing. And that's the perspective that we need to also understand. And the only status quo that will continue, and it's not in Bill C-15, it's the attitude of governments towards Indigenous peoples and Indigenous rights in this country. However clear your rights are in a treaty, governments will try to bypass, ignore them, and not implement them. That's how they've acted over the last more than 150 years, and that's going to continue, whether we like it or not. Like they spent close to $1 billion a year fighting our rights and our status in courts. That's not going to change, and I'm not surprised. But here we have a legislation that will assist us in those fights in the future.
Thank you. These are big questions, and these are great answers. And Grand Chief, did you have anything to add in terms of, there are questions just about supporting this specific piece of legislation. So I guess my question is why C-15 and why now?
Why C-15 and why now? What's the other alternative? The status quo? The why let me go back a little bit fast here. When the first delegates went to the League of Nations and couldn't get heard in the League of Nations to express their concerns, Chief Descahe and Ratana and the BC Douglas chief, treaty chief. And then till 1948, when a Universal Declaration on Human Rights was adopted, we had no voice internationally. In fact, in 1948, again, we were excluded. So we were considered non-humans. And it took us 8 years of debate at the United Nations over one letter, over one word that would tell the world we are actually human beings. And that was the refusal of states to use the word people with an S, peoples, to apply to us. And one of our elders, when I said that to him after I came back to report, he said, well, what are we then, animals or moose, elk, deer, what are we? I know why they don't want to recognize us as peoples, he said. Because if they do, they have to admit we're humans. And if they admit we're humans, they have to admit we have human rights. Because from 1923 until 77, we had absolutely no international voice. And many, many, many thousands and thousands, or even maybe millions of Indigenous peoples got killed because we weren't considered to be human. So it's important to note that as a reason why we had to go to the UN, we had to get recognition as human beings and then participate the best we could whenever we were allowed to define what those rights are. For example, the treaty rights. So I don't know, when you take the other side of the coin of this issue as the alternative, it's been boiled down to 3 words. First of all, my elders, when I asked them, what is it that you want from me when I go to the UN and internationally, they said, all we want is 3 things: recognition, respect, and justice. So I ask now, do we have recognition, respect, and justice today? So in the UN, it says it's for the dignity, respect, and survival of Indigenous peoples. So for those who oppose C-15 and oppose the declaration, that's what they're opposing. They're opposing our dignity, our survival, and respect. So they need to answer that as to why they would do that.
Miigwech, Grand Chief. I really wish we could keep talking for another hour. And every time I listen to the 3 of you speak and read your works, there's so much still I am aware that I don't know yet. I was looking back at, before we finish, I was looking back at C-15 and the preamble, and there's something in it that I think is pretty important to have put into law. And it says, whereas the implementation of the declaration must include concrete measures to address injustices, combat prejudice, and eliminate all forms of violence and discrimination, including systemic discrimination against Indigenous peoples and Indigenous elders, youth, children, women, men, persons with disabilities, and gender diverse persons. Whereas all doctrines, policies, and practices based on or advocating the superiority of peoples or individuals on the basis of national origin or racial, religious, ethnic, or cultural differences are racist, scientifically false, legally invalid, morally condemnable, and socially unjust. And whereas the government of Canada rejects all forms of colonization and is committed to advancing relations. To me, it's a very timely bill, given the conversations that we're having as a society. And so it's quite meaningful, I feel. And I thank you, Grand Chief, for your decades of experience and historical knowledge about the Declaration and the guidance that your elders gave you. Romeo, I know your elders have done the same, and your contributions have been enormous in the purpose of advancing respect for Indigenous rights, inherent rights, treaty rights. Unfortunately, Brenda had to step away because of her little one, so she's not here with us, but I feel the same about her dedicated scholarship and work as well. So, so miigwech, my hands to you. And I want to thank all of our nearly, I think it's over 1,200 registered viewers and those who joined on social media. This shows me that Indigenous rights are valued and are considered important by many people. I want to also thank my colleagues who are behind the scenes, Caitlin and Ailish, sorry, who are tech geniuses and have been moderating all your questions and making my job easier. If Romeo and Grand Chief, if you have 3 more words to finish us off, I would welcome them. One word on what the struggle for Indigenous rights means to you.
Well, I can start and let the elder finish with perhaps wiser words than mine. And just to mention that in the enumeration of the things that we have to combat, there's discrimination and so on and so forth. One word that is missing in there, and it's important given the present context of white nationalism all over the world, including in this country, is racism. Racism is not in that enumeration of things that we need to fight. I will also just mention a point about all the doctrines that are rejected by C-15, and Bill C-262 did the same thing, by the way. I think it's important to remember that these things will continue. Governments will continue to argue these stupid concepts against us. That will not change, even with C-15, but at least we will have a federal legislation tabled by the Minister of Justice and Attorney General of Canada that says that we reject these doctrines, racist doctrines, moving forward. There is a reason why in Chilcotin the Supreme Court had to respond, felt compelled to respond, that terra nullius, for instance, never applied in Canada. Supreme Court settled that question in one phrase in Chilcotin in 2014. For a long time, court cases in Quebec, the Quebec government argued over and over again that the Constitution did not apply in Quebec because they never signed it and because of its civil law tradition. Two things that courts have rejected all the time. So these arguments are going to continue, and that's the only status quo that will continue, in my view. Thank you for inviting me.
So to conclude in 2 words, royal assent.
Okay, that's a good conclusion. So the goal right now is to get this bill through before June, get it, royal assent. There's a lot of questions people have been asking about how to support this, reaching out to your MPs and the senators, urging them that this is timely, that this bill would help address everything, help improve everything. And so keeping that message consistent, Amnesty will continue posting updates on the process of legislation through the House of Commons and the Senate. And I just want to say finally, or one more time, miigwech minwa to our panelists today. All the best to you. Bama pinigagonin. And thank you to our viewers. Bye.
Thank you. Thank you.